You can be charged with a theft crime for stealing pretty much anything in the state of California. There is a threshold between a misdemeanor petty theft and felony theft, which is $950. Anytime that you steal something over $950, that can be filed as a felony and have huge criminal implications. Being convicted of a felony in and of itself is a huge punishment. In the state of California, if you are convicted of a felony, you can no longer own or possess a firearm, and you can no longer vote. Also, it becomes very difficult to get jobs when you are a convicted felon. It is very important that if you're being charged with a felony theft, that you call the law offices of Earl Carter and have our theft attorneys help you to work on getting this reduced down to a misdemeanor and even possibly negotiated so that it can be taken off of your record. A misdemeanor petty theft can have implications. However, the district attorney has huge leeway in working with those who are charged with misdemeanor theft on programs that can help them to have the charges against them dropped if they do some sort of a diversion or classes. Having a good attorney who understands the options and can help you to negotiate these charges down to a non-theft related crime and possibly taken off your record is very important when you're being charged with a theft crime. In the state of California, robbery is a very serious charge. Robbery is when a person uses force or fear to take something directly from someone else. This does not always require a weapon in order to be qualified as a robbery. It could be just intimidation or threat of imminent bodily harm that can lead to you being charged with a robbery for stealing other people's property by force. A robbery, because it is a crime against a person, is a strike against you, and it is also a very serious felony where you can go to state prison. If you've been charged with a felony, you need an aggressive criminal defense attorney who can fight for you to help you to get these charges reduced or dismissed so that you do not have a strike on your record, a felony conviction, or go to jail or state prison. So a burglary is when you enter a building without permission or by force with the intent to go in and steal or to commit another felony. Burglaries are a strike on your record and have serious implications. A burglary charge in the state of California is very serious. First of all, it's a strike, it's a felony, and you can go to state prison. If you're facing burglary charges, it is very important that you get a qualified criminal defense attorney who can help you to work on getting these charges dismissed or reduced from a strike or felony so that you can avoid going to jail and having a strike on your record. Sometimes crimes are qualified as either premeditated or a crime of opportunity. A premeditated crime is one that is planned, thought out, and carefully orchestrated. So, for example, if a group went out with burglary tools to go in to break into multiple cars at night, that can be filed as a premeditated crime. On the other hand, a crime of opportunity is one where the person had no intent of committing a crime, but perhaps saw something that they wanted and stole it at that time, in that moment, in a moment of weakness. A premeditated crime obviously is considered to be much different than a crime of opportunity. If you've been charged with a theft crime and this crime was not premeditated, you need a good criminal attorney who can explain to the judge that this was a crime of opportunity where you had a lapse of judgment, but you are not a criminal with criminal intent, and can work with the DA to then get the charges reduced or dismissed through a diversion program. If you have any questions about theft, robbery, and burglary charges, call Earl Carter and Associates.